the ruling of the court in respect of this exhibit. I have listened to the objection that has been raised by the defense, and which is to the effect that the witness, PW7, is not the author of that document that the prosecution seeks to tender in through her. And she's therefore not the competent person to have it tendered as an exhibit. I've also considered the argument by the prosecution that the witness has testified to the processes through which the same was produced. However, I find that whereas the witness has clearly described the document by her mobile phone number and the number of the sender and the transactions of the day, it is also my finding that no evidence has been laid regarding the steps taken to having the statement printed. Whereas she testified that she was called by police to go and print the document, it did not come out clearly whether the request was oral in writing, and it also did not come clearly in her evidence as to where she put the document after having it printed. Did she keep it? Did she hand it back to police? That evidence was not adduced. I have taken note of Rule 25(2)(f) of the Constitution Management of Exhibits Practice Directions 2022, which provides that any person with sufficient knowledge may tender in an exhibit, and whereas I agree that the witness has sufficient knowledge pertaining this document, I don't find it proper that she should be the one to tender it in light of the fact that the chain of its movement has not been laid out before the court. It should either be tendered in by the author or the person at whose instance it was printed. I therefore decline to admit it as an exhibit, but I find that the witness has sufficiently described it, and I will admit it for identification, and it is accordingly marked PEID 2.
Ensala ya kkooti ng'omulamuzi agambye nti awulidde okuwakanya okuva mu